Okay. Welcome, everybody. Can everybody hear me okay? All right. So I want to welcome our guest from the Rural Law Center, Heather, and she has graciously agreed to present a workshop on getting your affairs in order. And I think that there'll be a lot of really good information, and I'm going to keep everybody on mute. Please keep yourself on mute if you're on Zoom. Type your questions in the chat, and we will read them at the end. We'll have a Q&A opportunity. Heather Deare West, I hope I pronounced that correctly. You are joining us from Plattsburgh, so welcome. Thank you for doing this for us today.
Thank you. Good afternoon. My name is Heather Deare West. Nice try. I am the Director of Civil Legal Services here at the Rural Law Center of New York. I've been a practicing attorney for 24 years, predominantly in estate planning. So I know a little about what I'm talking about. But just to kind of get you familiar with our organization, the Rural Law Center, we are a not-for-profit. We offer free legal services and consultations to low-income New Yorkers in any of the 44 rural counties of New York. We are based out of Plattsburgh in Clinton County. I'm up near Montreal. Our services obviously include estate planning, which is what we're going to talk about today, but also pretty much any other civil topics such as uncontested divorces, consumer debt, bankruptcy, Chapter 7 bankruptcy, grandparent visitation, family law. So if there's anything that you might need help with, you can always do an intake online at our website, rurallawcenter.org. Or if you don't have access to the internet, you can always call. And I believe my contact information is probably in a handout, or if not, I'll put it in the chat later, so that you can call us and do an intake. So what I want to start with today is I do this presentation quite a bit because to me, it's so important. And the bulk of what I've always done in my practice is estate law. It's something I love to do. I know that probably sounds weird to a lot of folks, talking about wills and healthcare proxies and stuff, but I find it incredibly powerful and useful to make sure that everybody knows what these documents are, how they should be used properly, and why you need them. So what I will start with is, just so we can get this going, because I know there's a lot of people here today. So there are 3 documents I think everybody needs. I think you need a durable power of attorney. I think you need a healthcare proxy, and I think you need a last will and testament. Now, that being said, everybody is unique. So in terms of a last will and testament, some people may ask me about trust or direct beneficiaries. There are all sorts of unique situations. But I think for the basics, those are the 3 things you must have. So let's start off with the power of attorney. So if you're familiar with it, or if not, this is the basic explanation. A power of attorney is where you're called the principal, choose an agent or agents, you can have more than one, to act as if they were you in financial situations. So if you appoint an agent, they would be able to access your bank accounts, sell your property, maybe it's apply for benefits for you, fight with the health insurance company for you, sign contracts. Basically, anything financial you do, your agent can do for you. And again, you can have more than one agent at a time. In New York, we have what's called a durable power of attorney, meaning it's good from the second you, as the principal, sign it, and the agents sign it. And it's good even if you're healthy, okay? So let's say you travel a lot. and you're in perfect health, but you're not physically here to sell your house. And you get a fantastic offer, but you're not here to accept and sign the papers. If you have an agent, your agent can sign on your behalf, right? And you get to sell your house for $1 million and live happily ever after. That's the dream scenario. Really, why we want to have or make sure you have a durable power of attorney is if you get sick. There are a lot of circumstances where you may not be able to handle your finances anymore or handle your assets, most likely due to illness. And if we don't have something in place before that happens, meaning that you lack capacity, I can't make a power of attorney for you if you lack capacity. The ability to know what your assets are, who you want to handle them, what's going on. The only other option at that point would be guardianship. And guardianship is a court process that can be very costly and very time consuming and may not end in the result that you would want, had you known what was going on. The power of attorney is somebody you choose. A guardian may be somebody you would not necessarily choose. I will say first and foremost, nobody's family is perfect. And each family has their own dynamics. So sometimes you may not want your eldest to be your guardian, right? Or maybe your children married jerks and you don't want that jerk influencing your child. There are a lot of circumstances that you can't control in a guardianship because you're not going to be aware. Power of attorney, you get to choose. And your agent can be anybody that you choose who's over 18 and trustworthy, obviously, and responsible. So when I talk to clients about choosing who should be your agent, it may not necessarily be a family member. If your best friend is an accountant and your child has a gambling addiction, right? Choose the accountant. Don't choose the child. It's okay. It's okay to not choose a family member. Now, that being said, of course, the predominant choice is going to be a family member, but it doesn't have to be. So I always want to make sure that my clients understand that's okay. It's okay to choose somebody who isn't a family member. The idea is you're picking somebody to do a job to make sure that you're taken care of. And you deserve somebody who's trustworthy and you deserve somebody who's responsible, right? I also always suggest that you have an alternate name or multiple alternate names. Again, the reason being is if something happens to you and you're not well and something happens to your agent and you don't have somebody named, we're stuck again in that position where you don't have an agent. There's only guardianship. And again, that guardian may be somebody that you don't want. I always encourage everybody to have an alternate because unfortunately, or maybe fortunately, depending on your point of view, part of my job is to think of worst case scenarios, right? Now, first of all, people don't want to think worst case at all, but it's my job. And my job is to hopefully inform you, these are your options. You have agents, you have alternate agents. If you want more than one alternate agent, go for it. Let's have that. You want to be comfortable with who you are choosing. Keeping in mind now, so let's say you got set up with a power of attorney and you've changed your mind. You can change your power of attorney. You can revoke your power of attorney. In New York, it's done in writing and it has to be served on your agent. But definitely you are not stuck with your agent. Sometimes it seems like a good idea at the time and maybe it didn't work out. That's okay. That's okay. You can revoke this document. Now, the power of attorney does have certain limitations on it, and we want those limitations. Or at least I would want these limitations. One of those is that the agent cannot make gifts or transfers to themselves, right? I think this is the big fear when we talk about powers of attorney, that they're going to be abused. And, truth be told, it does happen. So part of the built-in protection is that the power of attorney says, if you're the agent, you don't get to make transfers to yourself unless we specifically put language in that power of attorney. So it's like an active choice to do that. I try to counsel my clients not to do that because, again, we want to make sure that you're protected. The agent can't make transfers or gifts over $5,000 a year in total. Now, that's not a requirement that they make gifts, but if it's something you normally did, your agent can continue to do that, but only up to $5,000 a year. When we were doing, when things were different, those kind of gifts made sense when we had like a lower estate tax, which I'm not even bothering to get into, but it was a lot lower figure than it is these days. And we were doing estate tax planning. That made sense then. Now it doesn't. So I would keep that $5,000 limit. Like I said, though, if you want, you can modify the power of attorney. You can remove that limit. You can allow your agent to make gifts to themselves. It's your choice. And again, I would suggest, talking this over with an attorney when you are making these choices. You can have somebody called a monitor for your power of attorney. Now, a monitor isn't somebody who has the capacity of an agent to sign documents for you. Their job is to kind of keep an eye on your agent. So what they get to do is ask your agent, hey, I want to see the records of what you've been doing so that I can make sure that you are doing everything properly. Now, a lot of times I'll get pushback on this because, again, typically your agent's going to be somebody you love, you care about, and you think they love and care about you. And so they think there's no need. Most of the time, probably not, but it doesn't hurt, and it is an option. Certainly, if your agent were somebody that you were literally hiring, like say you went to your accountant and say, I want you to be my agent, then you could pay, you could have a monitor and say, let's make sure you're behaving yourself. You don't have to, but it is an option. There's also the option to pay your agent for acting as your agent. I have to say, I never recommend this. And the reason why is, again, most of the time you're choosing family members to be your agent. Now, when you have family, add somebody you've chosen above maybe other family members, and you throw in money, can you see the fight that's going to come a mile away? So I never recommend that. Now, the agent can be reimbursed for costs that they incur on your behalf. Say they paid your electric bill for some reason, and they certainly can be reimbursed for that. But I think for everybody's sake, don't pay your agent. Again, if you were hiring somebody, then obviously you've got to pay them. But if you are appointing a spouse, if you're appointing your children, your grandchildren, they do not need to be compensated. I just think it's an argument waiting to happen. All right. That is my brief scenario about what a power of attorney can do. And I know you all have questions, and I'm going to be happy to answer them afterward. I just kind of want to make sure I get you the basic information, and then we can get down into some more details. Somebody asked about, what about a friend? Yes, a friend can be your agent. Again, your agent does not have to be a family member, does not have to be your spouse. Sometimes I get a case where the spouse may have dementia. Obviously, then they cannot be the agent. Sometimes, again, nobody's family's perfect. Maybe your children or your child has a drug addiction, alcoholic, just really terrible with money. They should not be your agent. Okay. And things change. That's why you can revoke these documents. So certainly, like I said, we're looking for somebody responsible and trustworthy. All right. And over 18, obviously. The next document I want to hit on is the healthcare proxy. And again, like I said, I'm happy to answer all your questions. We're just going to go through and then you can hit me with all of them. So your healthcare proxy. I'm sure a lot of you have been to the doctor and they're going to ask you, do you have a healthcare proxy? And hopefully you're going to say yes. Probably some are you going to say no. So what is a healthcare proxy? It's a document where you, again, you're the principal, get to choose an agent who can speak on your behalf and make medical decisions for you when you can no longer do that for yourself. For some reason, you're incapacitated, whether it be through an accident or an illness, but something has happened where you don't get to tell the doctors what kind of treatments you want or for how long or how you feel about artificial nutrition and hydration. So you're going to choose somebody who's going to be your agent. And that's the person the doctor is going to ask, what about these medical decisions? Again, it can be a spouse, it can be your children, it can be your friend. Also, again, you want to have an alternate because again, I can't, no lawyer can fix documents after you've become incapacitated. If you regain capacity, it is always your decision about what happens to you, right? But so we're talking in those instances where something has happened and you can't tell them, can't tell the medical staff, the doctors what you want. Those decisions can include DNRs, can include artificial nutrition, hydration, comfort medications, basically anything. And it is not, how do I want to say this? An automatic take me off of everything. People worry about that. It's whatever your wishes are. So if you want everything under the sun tried for you, if you want machines and drugs and treatments, that's what you tell your agent. If you want some of that, that's what you tell your agent. If you want none of that, that's what you tell your agent. So this does involve having that hard conversation about what you want to happen to you if you were to be in that position. I think a lot of hesitancy occurs when it comes to this part. This is where people get stuck. Nobody wants to admit they may become incapacitated. Nobody wants to admit that they may die. Eventually, we all are, right? But we need to make sure not only are we prepared, but our families are prepared. So we have to have the difficult conversation because they have to know, what do you want? What are your wishes? Whether, how do you feel about this treatment or that treatment? It's whatever your personal wishes are. And I cannot emphasize enough how important these conversations are. And I will tell you a story about that later. You can have alternates. Again, a healthcare proxy is something you can revoke. A lot of times you'll hear things about living wills. They are different from healthcare proxies, and living wills also get confused with last wills and testaments, which we're going to talk about next. But a living will tends to talk about specific situations. If I have a heart attack, I want this done. If I got stung by a bee, I want this done. Healthcare proxies tend to be very broad. Living wills also tend not to name an agent. So we may know your wishes, but who's going to speak for you? Under the healthcare proxy, that's where you name your agent. Now you can have a combination. You can have a healthcare proxy, and if you already have a living will, that's perfectly fine. The living will can offer guidance. There are some other things. Obviously, there are DNRs, do not resuscitate. If you have a significant illness or a terminal illness, you may have a conversation with your medical doctor where they'll do what's called a MOLST form, MOLST, a medical order for life-sustaining treatment. And it's medical orders. If they're old-fashioned and they do it with paper, you'll know it because it's hot pink. The paper is hot pink. You cannot miss it. And that travels with you. But I think at minimum, you need to have a healthcare proxy. All right. So again, that's my kind of condensed version of a healthcare proxy. So we're going to move on to the big topic, the last will and testaments, right? So power of attorney and healthcare proxy, those are things that we have in place while you're living, right? Last will and testament is after you're gone, right? So last will and testament, in essence, is simply a document that tells us, society, what you want to happen to all of your possessions when you're no longer with us. And it can be as simple or as complex as you need it to be. In essence, it simply says, I'm Heather. I want all of my stuff to go to whomever, right? If you're married, typically it goes, I want everything, I leave everything to my spouse. And if my spouse predeceases me, I leave everything to my kids, equally or unequally. It does not have to. It's your stuff. You can leave it to whomever you want. The one exception to that is you cannot totally disinherit a spouse, all right? So maybe some of you spouses are breathing a sigh of relief. You can't be disinherited, but everybody else, that's your choice. These are your possessions. These are your assets. You worked all of your life for all of this. It's your choice what you do with it, okay? It is important that it be in writing. A lot of folks think, well, I don't have anything. Yes, you do. You do. You have something, right? You have a house, you have a couch, maybe you have a dog and you want to leave that dog to your best friend. You can do that. You can do that in a will. Wills also can cover some difficult situations. So again, if you say have a child who has special needs, you want to make sure you address that in your will, because you don't want to leave a child an asset, that child has special needs, and then accidentally trigger the revocation of their benefits, right? So in that will, you can create what's called a special needs trust so that they have use of those assets and you protect their benefits, right? If you just kind of don't have a will and they automatically inherit under what's called intestate law in New York, so they may get $20,000, but you've wiped out their benefits. That's not what you wanted to do, right? So there are things that we can address in the will like that. Let's say maybe you have grandchildren that you want to be the beneficiaries. That's fine. But if they're under 18, they're too young to take that money. And you therefore, hopefully, if you walk away from today and say, I need to make a will with a lawyer, you build a grandchildren's trust into your will that says, if any of my beneficiaries are under whatever magic age you think is appropriate, I have a trust in my will and it's going to hold the money for them until they reach this magic age. And in the meantime, the trust can pay for their college, it can pay for their maintenance and their support. Because if you don't, if you leave money to a minor child, depending on how much it is, if it's over $10,000, then you got to go to the court and have a guardianship set up, or at least your children do, or whoever's taking care of your grandchildren. They have to go to court and they have to set up a custodial account, and every time they want to get something, they have to go to court to get the court's permission. And maybe the person in charge of the money isn't the person you wanted it to be. Here in a will, you control what age they receive the money, who's in charge of the money, and who the alternate should be in charge of that money, and what the money can be used for. A will, like I said, can be something as simple as I'll leave everything to my spouse and then I'll leave everything to my kids equally. But let's say you have your grandmother's engagement ring and you promised it to your eldest daughter, and you've got 5 daughters. And when you pass, all 5 daughters want that engagement ring, right? Is that a fight you want? No. So you put in your will, grandma's engagement ring goes to Alice. A lot of the fights I see when it comes to estates aren't necessarily over the big expensive things. It's over the sentimental items, the things that mean something. Grandma's quilt, granddad's moat. Those are the things that if you have promised them to somebody or you do want them to go to somebody specific, put that in your will, please. Some of the worst fights I've seen as an attorney have been over things that I would never think anybody would ever fight over. My favorite being the big fight over the black velvet painting of Jesus. So, that was a nasty fight over a black velvet painting. I've also had fights over little glass owl figurines. I've seen fights over heavy duty plastic plates. I've seen fights over a telephone. Please don't assume that your kids are going to know what you want. Be safe. If there are special things, if plastic plates are special, put it in your will. Put it in your will and make sure that that's what happens, or give it to them before you die. You can always do that. In your will, you also want to choose who's going to be in charge. And this is important. So again, we're talking about basically a job. Who's the person that is responsible and trustworthy and willing to do this for at least 7 months in New York, and the state stays open at minimum 7 months, because that's the time frame creditors have to file a claim against your estate if you owe them money. So at minimum, you're looking at somebody handling this for 7 months. Realistically, I'd say it's about a year, right? Between, if you have a house, if you have bills, if you have other issues, it's a kind of a long-term thing. Again, you want to name an alternate. If you have trust in your will, you want to name a trustee. The executors and the trustees can be the same person, but they don't have to be. That's perfectly fine if you choose somebody else. They can be your family, they can be your spouse, they don't have to be. So again, you have to take a look at your situation realistically and think, who's the person suited for this job, right? Because it is a job. There's a lot that goes on when folks die. And I think there's almost a panic about needing to get all of these things done immediately and getting things in place. There is no time frame where you have to file a will. Right. So that's the first thing. They can take a breath. They can figure out what's going on, what your assets are, how are they going to deal with your debtors. There are certain things that you can do to kind of supplement a will. And by that, I mean, if you are a joint owner on something, so like with spouses, usually you own a bank account jointly. Sometimes you don't, that's fine. But if you have like joint accounts and both of your names are on the deed, when one of you passes away, the first person passes away, the survivor may not necessarily have to probate the will, and probate is the process of going to court, because as a joint owner or a direct beneficiary, the survivor already automatically owns everything, right? So we'll see a lot of that. A direct beneficiary is just somebody you name as the beneficiary on maybe a bank account, a life insurance policy, maybe on stocks, it's called transferable on death, payable on death. Those all bypass a will. So sometimes I'll find somebody who has all joint owners or direct beneficiaries or payable on death accounts. And they ask me, do I still need a will? Yes, because inevitably you forgot something. I don't know what, but always you have forgotten something. So we always want to have that backup of a will. And like I said, it doesn't have to be complicated. It certainly can be. Again, looking at your situation and what your goals are and who your family is and what you want to happen, that all kind of creates this will. There's also, I know, and not to drum up business just for us lawyers, especially for me, my services are free. So, I don't have anything vested in this. Occasionally we'll get folks who take a will offline. They download a will. Please don't do that. It's almost worse than not having a will at all, is if you do a will incorrectly. There are certain things that need to be done when a will is signed. Usually those aren't done properly. Sometimes people will say, I leave my house to my son, and that's all the will says. But they have more than the house. There's the car, there's the bank accounts, there's the furniture, and the will doesn't mention that, right? I'm hoping, and I think one of the questions put forth is, what happens if you can't afford an attorney? Please look for somebody like our services that can help you. Again, a simple will is better than no will, but it's almost always better than anything you can get off the internet. I'm always scared to see those because I know something's wrong. And it's not just that it messes up what your wishes are, but it's going to cost your estate more because you're going to have to pay to get that fixed. And by that, I mean, you may have to pay extra for finding family members. You may have to pay extra to figure out who's who. If there's a will contest, which are very rare, by the way, that's going to be an expense to your estate, all of which can be avoided if you go to a professional and say, this is what I want. Here may be some issues that may be coming up. Here's how we address them, right? Just to kind of throw it out there, I know a lot of folks are always worried about will contests. They sound very dramatic on TV. The reality is no. First of all, there is no, in New York, you can, but I have never done a will reading. I have never gathered the entire family up into the conference room. I've never had to read a will. That's not how it's really done. Again, that makes great TV, but the reality is you don't want to pay an attorney just to sit in a room and read a will to you, right? You don't want that. So a will contest is where somebody's protesting the will, but they have to have legal reasons to do that. The fact that they're unhappy is not a legal reason. The fact they think it's unfair, not really a legal reason. So if you do a will of a professional, half of those legal reasons are taken care of. One of them is going to be, did you know what you were doing? Right? One of the legal reasons is they were incapacitated. They didn't know what they were doing. You work with a lawyer, there's an assumption that you knew what you were doing. The lawyer looked at you and said, you know what you're doing. That takes that out of the game. Also, there can be the argument that you didn't properly execute the will. You didn't sign it properly. You didn't have the proper witnesses. It wasn't notarized. Work with an attorney. We make sure that that's what happens, that those things are done, right? Somebody unduly influenced you. Again, working with a professional, we're going to, I have in-depth conversations with my clients. I want to make sure that whatever I have you sign is what your wishes are, right? So again, working with a professional kind of, tampers down those arguments. Now, if somebody's going to be unhappy with your will, they're going to be unhappy and they can cause a fuss. But a genuine will contest is, I think, kind of rare. A good will contest is probably a good $20,000, right? And that's probably cheap. If you're going to disinherit somebody in a will, which you are allowed to do, again, you are not required to leave children or grandchildren things. You want to address that in the will specifically. You want to say, I am not leaving so-and-so anything for whatever reason. It doesn't have to, you don't have to get into great detail. Please remember that wills are public documents that last forever. You can say something as simple as, our relationship is broken and I don't care to leave them anything. That's fine. I have seen wills where the gentleman, and I'm not saying it because this is being recorded, I'm not going to use the language he used, but let's say his wife was a floozy. That was a term my grandmother would use. He put that in his will in much negative terms, much worse terms than floozy. That will is a public document, right? And so for eternity, if anybody looks up at his document, they're going to say, oh, his wife was a floozy. You don't need to do that. You don't need to do that. You can just put something as simple as, I don't want to leave them anything. You do want to make sure you put it in your will that you're not leaving them anything, because you don't want the argument to be, oh, that person was forgotten. And please, here's another old kind of scenario. Do not leave anybody $1. or $5 or $10. Don't do that. Leave them nothing, flat out nothing. The reason why we don't want to leave anybody $1 or $5 is because that gives them certain rights. So one of those rights is at the end of the estate, the executor is going to go to everybody and say, please sign this form that says you got everything that you are entitled to, and you're not going to make me do a formal accounting, which is going to cost money, and everything's okay. You leave somebody $1, you think they're going to sign that form? No, no, they are not. They're going to make you have a formal accounting. They're going to come to court and say, I object. That dollar is going to cost you thousands. Better just to simply say, I'll leave you nothing. All right. And like I said, give a reason. Doesn't have to be a mean, floozy reason, but give a reason. I think with wills, if you don't have a will, New York does have rules about what happens to your estate. Again, it may not be what you want. You know, if you had certain wishes, they're not going to be known. You may have somebody in charge of your estate that you did not want. So at minimum, have a simple will, you know, at minimum. Again, each of you has your own issues and circumstances and things that need to be addressed in your will, whether, you know, we have grandchildren we may want to leave something to. We may have children with developmental disabilities that we want to make sure are taken care of, but we want to make sure we don't take away their benefits accidentally. You know, we may have children who married people we do not like. And so maybe we put their share in trust to make sure that that in-law does not get their hands on their money. You know, there are so many things out there that could be addressed by a will. But in essence, is how you take care of your family, right? Or your friends, or your favorite charity. Also, you can take care of your animals, right? So if you have Fido and you want to make sure Fido goes to a good home and you want them to go to your best friend, put that in your will. I've done that plenty of times. I have had, just to kind of go a little astray, I did have a client who had significant money, had lots of young animals, like puppies and kittens, and she left $250,000 in a trust to make sure they were all taken care of. So people love their animals. You don't have to go that far. You don't have to leave significant amounts of money, but you can certainly say, I want Fido to go to so-and-so. So, and again, you know, I'm happy to talk about this. I can talk about this sort of thing all day long, but I do know our time is limited. So I do want to kind of wrap this up to kind of prove a point. So every time I do this presentation, I say, I'm going to tell you a sad, sad story. Okay. And this sad, sad story is not to elicit sympathy, but it's to prove the point about unpredictability. And of course, it's my sad, sad story. Okay. So a few years ago, my mother, Victoria, who was English, that's important. Just because she was English, that's important. She would travel back and forth from the US to England. She had a gentleman friend there. She had family there. She would spend months there. And then she would come home and stay with me. So looking back, when we were talking about that power of attorney, about how it's good even if you're healthy, that's what I'm talking about. She spent months in England. You know, the IRS still wants their money, right? You know, people want to be paid. So even though she was healthy and fine, she literally was out of the country. So as her power of attorney, I was able to use that to make sure her bills were paid on time. If things needed to be filed, I was able to do that. Okay. One day she was home here in America, but she wasn't feeling well, you know, and it was flu season. And for some reason, I don't know how this happened, I didn't have any tea in the house, right? My mother's English. You can only imagine the uproar. But I also didn't have ginger ale, and I didn't have crackers, so I went off to the store to get all of the supplies. Because if you know anybody who is English, you know that tea solves everything. And somehow I was a terrible daughter. So I went to the store about 45 minutes later. I came back and my mother was still sitting in her chair, except now her eyes are listing to the left. And though she can hear me and answer me, she's not looking at me. And she had a terrible headache. So I called the ambulance and off we go to our local ER. She's progressively getting worse and the doctors think she's had a stroke. And this probably is just the worst thing I could possibly hear. She's had a stroke. My mother's a very vibrant person, very smart, very funny. But I can slowly see that disappearing while we're in the ER. But it's not quite like a stroke. And as we're talking, I can tell that she's not able to make decisions for herself. This is where the healthcare proxy comes in. I have to immediately start making decisions for my mother because she is losing capacity at an amazing rate. Hour 4 in the ER, the doctors are still not convinced it's a stroke, so they take her for testing. And they come back and they tell me my mother has a grade 4 glioblastoma, a brain tumor. She has brain cancer. Out of nowhere, there's, this sort of cancer, there's no family history. She was fine the day before, less than 12 hours, she was fine. But now we are in a situation that eventually this will kill her. But now she has lost capacity because her brain has swollen. And she can't make decisions for herself. If I did not have that healthcare proxy, if I did not have that power of attorney, that horrible situation would have been 10 times worse, because then I would have been in a panic about what am I going to do? How am I going to take care of these things? Right? And I know it sounds strange to say this, but it is a gift to have those documents. It's a gift to your family because then they know there's something in place that should, God forbid, something horrible happen to you, you have something that can just immediately go into effect. And that is what happened. That is what happened. For the next 8 months after that diagnosis, I was using that power of attorney and healthcare proxy daily. Every single decision that was made, I made with what her wishes were. We, prior to this, because, I'm a lawyer and she raised me, so we had these conversations. Remember me telling you about having those difficult conversations? I know they're difficult because I had them. We had those difficult conversations many times, not only with me, but with my brother and sister. So they both lived away from here. But I still obviously talked to them about what was going on. I can honestly say to you, and I know it's rare because I've seen it, not one time did my brother and sister and I argue or fight over what was happening with our mother. There was not one disagreement about what her wishes were, about what the things I was doing with her, about what the next steps would be, because we had those conversations, right? I've seen families where those conversations have not been had, and it is destructive, so destructive. It's also, and like I said, I know it sounds weird to say it's a gift, but towards the end where we had to make those final decisions, I could make them knowing I was making the right decision. Unfortunately, I had a friend at the same time who was going through the same thing with her father. He had, I think, colon cancer at that time. And he passed 10 days before my mother passed. And I think one of the saddest things I've ever heard is my friends say to me, I'm not sure I did the right thing. I'm not sure I made the right decisions for him, because they had never had that conversation. And that haunts her. So I say this, and again, I tell this story not to elicit sympathy, because I want you to realize how fast things can change and what a gift it is to know that I did the right things, right? That's what you do. That's what you can do. Of course, she had a will. The will actually is almost an afterthought because my brother and sister and I, again, we all knew what was going on. There were no arguments. That alone is a gift. Like I said, I've seen families have huge, huge fights about what happens to mom, what happens to dad. You don't want to leave that sort of thing, right? And everybody does, what they can. Sort of as an aside, during this horrendous time, everybody acts differently or acts, in accordance to their personalities. I'm very organized and very take charge, so obviously I was in charge of what was going on. My brother is a gardener, so he planted a garden for my mother because he didn't live up here, but he came, I say up here because I'm in Plattsburgh, but he came and planted a garden for him because that's what he did, so that she would have something beautiful to look at, and that was his contribution. My sister couldn't handle anything with health, but what she would do is come and clean my apartment top to bottom, which I appreciated, and she organized my pantry so it made sense. I don't know what that meant, but it looked really pretty afterward. And she also color coordinated my tea towels. Again, I don't know what that does, but it made sense for her, and that's how she helped. And again, that's how people contribute, and that's what happens. Usually by this time, I also have a public shaming with my paralegal Tracy. Unfortunately, because we're doing Zoom, I don't have her here. I publicly shamed Tracy, my paralegal, of 18 years. Because despite the fact that she works for lawyers and has always worked for lawyers, despite the fact that she has worked with me for over 18 years, her will is so outdated, it does not include her 20-year-old daughter. It's a joint will, which we don't even do anymore. She doesn't have a power of attorney. She doesn't have a healthcare proxy. And the reason why I bring this up and I publicly shame her, and she knows I do this, by the way, she understands, is to say we understand that these are not easy things to do, right? We get it. We know that it's hard to come and talk to an attorney, for whatever reasons. People are afraid they're going to come talk to an attorney and do a will and then get hit by a bus. That has never happened to me, by the way. But we understand it can be intimidating and scary, and you don't want to think about these things because these aren't happy things, right? But having these in place, like I said, is a gift. Very strange gift, I admit, but it is a gift. And it's also peace of mind, not just for your family, but for you. So that when you're no longer there to guide your family or take care of things, you have these documents in place that can do that for you. And I will continue to publicly shame Tracy until she does get off her behind and update her documents. At some point, hopefully she will do that, and then I'll have to find somebody else to publicly shame. But until then, it's Tracy. So I think I'm good on time and we have time for questions. But basically that is my reasoning for the 3 documents. I'm looking forward to your questions. I hope this gave you some good information. I hope that you take this information and be brave, and finally break down, do those documents, have those chats, and hopefully, if you come through us, we can help you. So I'm going to turn it back to you, Nancy, and you can tell me where to go from next.
Okay, thank you.
It's so hard because usually when I do these things, I interact a lot with my audience. I chat with them and stuff. So this is a little different. So I hope it came off well and that everybody got something useful out of it.
Yes, very much so.
Excellent.
Thank you. So I guess what we'll do is, I had emailed you some questions that folks had given me in advance. Why don't we tackle that first?
Okay.
And then we'll go to the chat, and then we'll go to people in the room and on Zoom.
Sounds good.
All right, so I can bring those up if you don't have them.
I do have them if you want me to read them off or.
Sure, yeah, why don't you do that?
Okay, so one of the first questions is, in general, how does the legal process tease out, consider, and document the emotional, social, and spiritual values a client brings to end-of-life planning? That's a bit difficult to answer because it depends on the attorney. You know, we rely on clients to bring those things to us. How that attorney deals with them is their practice. For me, I'm very, and I think you can tell, interested in the person. Some attorneys very matter of fact. So they may not necessarily address those questions. If they are important to you, bring them up. Don't ever forget, you're paying for services if you're not coming to somebody like me. But if you're paying for services, you know, you're paying them to do a job. So if something's important to you, bring that up. You know, for me, that's kind of natural. We have these, like I said, these long conversations. But yeah, I think unfortunately it can depend on the attorney. So that's the best I can do for you on that one. So the second question is, in general, what homework should a person do prior to meeting with any attorney to be best prepared and make the process more efficient? I love this question. So what you want to do is you want to have, in general, a family list. You know, who are you married? Are you widowed? Are you divorced? Do you have kids? You know, have any of your children predeceased you? If so, do they have kids? And I'll go over into that in a bit. You know, what are your assets? Now, you don't necessarily have to, for somebody like me, and again, it may depend on the attorney. I don't necessarily need your account numbers, but I would want to know what the value of the assets are, you know, so I can kind of keep in mind, you know, again, currently I'm not worried about estate taxes these days because it's so ridiculously high, which is awesome. But I do want to know what the value of your assets are. I also want to know if you have significant debt. By that, I mean like a mortgage, a car loan, any kind of personal loans, any liens, judgments. That I think is a good basics. Do you have any interesting assets? Do you have, you know, a company, a family company? You know, because those kind of family documents or corporate documents we may need to look at. When I'm talking about family, in New York, whether you have a will or not, there are certain people who are entitled to have knowledge about your estate, right? So that's going to be your spouse, your children, possibly your grandchildren. But sometimes we'll run into folks who are not married or divorced or don't have kids, but maybe have brothers and sisters, nieces and nephews. We're looking at creating a family tree. So you want to go to what I would call the next living line, right? So who's your nearest next of kin, right? We want to know that information. I would keep that in the file. Again, not because you have to leave them anything, not at all. But when you probate a will, when you're doing the process of going to the court and saying, here's my last will and you know, my executor saying, here's Heather's last will and testament. We want you to accept it. We want you to appoint me as executor, because the will nominates somebody, but it's the court who appoints them. You know, and here are the people that might be interested in her estate, so that we can get waivers from them who say, I've seen the will, I'm not objecting to it, right? But we always need to look for the next living relative. If you can do that, that could potentially save your estate a lot of money. Because if we don't know who your relatives are and you have passed away and I don't have anybody to talk to and I got to find this out for myself, somebody's got to do research. That research can get expensive. I have had an estate here where the gentleman wasn't married, had no children, but had lots of brothers and sisters. He had 6 living brothers and sisters. One sister had already died, but she didn't have any children, so that tree branch ended. His mother had died, but his father had, I don't want to say disappeared, but had left 50 years prior. So we had no proof that he was dead. We had no proof that he was alive. But we had heard rumors. We figured out after talking to everybody that if he would be in New Mexico, in a terribly rural part of New Mexico. So because I have to prove to the court I tried this, we got special permission to print a notice in this paper in New Mexico that was so rural. The paper printed once a month, not even once a week, once a month. We had to get special permission, and I'm thinking most of the times nothing ever comes of this. Well, lo and behold, somebody, the father's friend, found it, showed it to the father, who nobody had heard from for 50 years. And he contacted us. And that father had a whole other family, another 6 kids. So we had to not only get documents from the father, we had to get documents from all other the 6 kids. Well, some of those 6 kids had died, and so we had to find their children. Well, some of those children had died, so we had to find their children. In the end, I landed up finding 36 people. I did this while I was with the Rural Law Center, while I'm here. Had I been in private practice, that would have been an easy $10,000. So when I say do a family tree, save yourself some money, save your family some money, and look for that family tree. And then again, once you start talking to an attorney, they may ask for more specific things, but I think in general, if you have that information, you're off to a really good start. The next question, in general, how important is it for an individual to work with an estate lawyer over a lawyer without elder law, estate planning as a specialty? For myself, and again, this is because I've done this for years, I'm going to say it is very important. Any lawyer can draft a will. That's not the issue. What you're paying for, I think, if you're paying, or if you're coming to see somebody like me, is the ability to spot those issues that most lawyers aren't going to recognize, such as the fact is, if you tell me you want to leave everything to your grandchildren, great. Does the other attorney know to ask, are those children over 18? Do any of those children have special needs? Do we need to do a trust, right? And if we're doing a trust, who's going to be the trustee? I want to leave everything to my son. Oh, all right. Does anybody have any special needs? No? Yes? Well, yes. Then we maybe need a special needs trust. Who are we going to name? I'll pick my eldest son. Well, is your eldest son a responsible person? Is he trustworthy? Well, he's got a drug problem. I'm going to tell you no. So, take it with a grain of salt, because again, like I said, I'm an estate attorney. So of course I'm probably going to say, yes, choose us. But I do think that there are probably some issues that we're better at spotting than somebody who doesn't have experience. So there's that. In general, next question, I'm sorry. In general, what DIY estate or end of life planning avenues do you recommend for low income people who can't afford an attorney or have access to RCLS? With low income folk, again, you have organizations like mine, the Rural Law Center. We operate for low income New Yorkers in any of the 44 rural counties. And I understand, rural counties, it's hard to get attorneys just to begin with. So there are services like us that, please go to our website. Please feel free to do an intake. If you qualify, we're happy to do this for you. I spoke generally about, picking a will form offline or, off the internet. I always worry about those. Same thing with the durable power of attorney. 2 years ago, New York made some big changes to the durable power of attorney form. So if you pick the wrong form, it's going to be invalid. And it can be a bit of a complex form. So you want an attorney to go through all of that with you. And the new form also requires 2 witnesses. Old forms don't. So it's kind of important to make sure that. Probably the easiest one to do on your own is a healthcare proxy. Typically, your doctors are going to have blank forms. Hospitals are going to have blank forms. It's pretty much the same form. You could go online to the Department of Health and look for a healthcare proxy. Just remember, you need to choose a agent. For a healthcare proxy, you can only choose one agent at a time. That's the law. Unlike the durable power of attorney, where you can have multiple agents, one agent at a time for the healthcare proxy over the age of 18. The document does need to be witnessed. So you sign it, and it's signed before 2 witnesses. Doesn't need a notary. but it does need 2 witnesses.
No.
So that's probably the easiest one to do is a healthcare proxy. What are the biggest challenges to estate planning? Going to see the lawyer. That's the biggest challenge right there and then. Coming to see somebody like me. I always say this, I don't think I'm intimidating, but going to see a lawyer can be intimidating, right? And it can be expensive. No joke about it. But actually getting past that hurdle is the biggest problem for me that I've seen in all the years I've worked. Just having people come in and talk to me. Getting past that idea that one day I'm going to die and I won't be here, and people don't want to think about that. They don't want to think about bad things happening to them. But I think as we've talked today, and like I told you my sad story, things do happen, and they happen out of the blue. So kind of getting yourself together and taking the leap and going to find help and getting these documents done. I think that's the biggest challenge.
Thank
So
you,
those are
Heather.
the questions I had. Yeah.
All right, so I'm going to go to some of the questions in the chat. And I'm also going to go back to something you said and ask a question. So you said something about they no longer do joint wills for spouses. What if you have a joint will? And obviously it needs to be updated, but something happens to one of the spouses.
It's still good. Wills are
Okay.
still good until you revoke them, no matter how old they are. The problem with old wills is, again, we have joint wills. Wills are witnessed, and old wills may not have what's called a self-proving affidavit. So witnesses sign as a witness, and then they can also sign these days an affidavit that says, I witnessed so-and-so. I saw the witness, they saw me, I saw them, everybody looked like we knew what we were doing. And that affidavit can be put into the court so that witnesses don't have to physically come to court and testify that, yeah, that's my signature. Old wills don't have that, which means then we have to locate the witnesses. And if those wills are old, the witnesses may not be alive. And then you have to do special paperwork that asks the court to please accept the will. I found somebody who recognizes the witness's signature. I found somebody who recognizes the testator's signature. Again, it's one of those things that can just add time and money to your estate. But in and of itself, a will is still good unless you revoke it.
All right, thank you. Thank you. All right, I'm going to jump up to the top of the chat and start from the beginning. So is there any New York state law that says you can't dispose of remains as you wish? So a little bit of a different question.
Yeah, there are laws regarding the disposition of bodies. There is cemetery law. And there are funeral directors are required by law to do certain things. If the concern is what happens to me after I'm gone, who's going to take care of those things, my wishes and stuff, you can do what's called designation of agent for disposition of remains. It's a form that says when I die, my sister's going to make the arrangements for me, and here are my wishes. So you can choose somebody to be in charge of your remains. It is a form from the Department of Health, and also funeral directors will have it. Or somebody like me who does this for a living, they may have it too.
All right, thank you. Is a power of attorney good if the agent's name is not on your bank account?
Yes. In fact, that's exactly why you want it. So what you would do is you would take a copy of the power of attorney to the bank so they have it on file. But yeah, you don't have, the whole point of a power of attorney is probably the person's name isn't on the bank account. The power of attorney allows the person to have access to that bank account and to sign checks for you. And what you would do is you would sign those checks as an agent. So let's say I was my sister's power of attorney, and I, had access to her bank account and signed a check for her. I would say, Heather Deare West as agent for Tracy Taylor, or Tracy Taylor by Heather Deare West as agent. You just need to recognize that you're the agent, but yes.
Okay, thank you. And then there was a question about, is it okay to pay a friend, who's your power of attorney?
Absolutely. You can pay any, you can pay your family members, you can pay your friends to be your agent. That's totally up to you. My point being is when we have family members involved and money, usually there are great big fights coming down the road. So that's why I don't recommend it. But you certainly can pay your friend or a family member to act as your agent.
Okay. Let's see. I'm gonna take, let's see, a few more. I want to make sure I didn't go up too far. Okay, so. There we go. Sorry about that. Is a healthcare proxy the same as a living will declaration?
No.
No.
So a living will and a healthcare proxy are two separate documents. A healthcare proxy generally names an agent, where a living will doesn't. A healthcare proxy has an actual New York statute behind it. Living wills, though, are recognized. It's all case law, meaning, things have actually happened and the courts have looked at them. You can have both, like I said before. A living will tends to be very descriptive or very specific, whereas a healthcare proxy is broad. If anything happens to me, so-and-so gets to make my medical decisions. Where a living will may say, if I have a heart attack, these are the treatments I want, and it does not name an agent.
Okay, I think we answered the next one, about how expensive lawyers can be. What are my options? So you mentioned the intake process on your website or
Yes.
by calling, right?
Yes.
Are there other options? Someone mentioned do it yourself. You didn't recommend going online to download the do it yourself documents because they can be full of problems.
Yeah, typically when I see, I will get them, after somebody passes and their family comes to see us to do a state administration. I always kind of flinch when I see a self-done will, only because, again, there's probably something wrong with it, and it just causes extra burden to the family.
Okay, are you familiar with 5 wishes? If so, is that a good living will and healthcare proxy?
No, it is not the same thing. It's more akin to a living will. It describes, and if you go to the website, it's a really good document. There was an early question about emotional, social, and spiritual values. The 5 wishes addresses those in terms of healthcare and incapacity, but it is not the same thing as a healthcare proxy.
Okay. Someone says, I have a will from the internet that was notarized. Is it okay to rip it up or can I make changes with an attorney?
Please make changes with an attorney. Don't rip, well, without seeing the will, I can't tell you whether to rip it up or not, so don't take my advice on that, but please go see an attorney. You can bring the will with you and they can take a look at it and tell you if it's good or not. But they're very likely going to suggest, let's redo your will.
Okay. I also read it's not good to have an executor that is out of state. Is this true?
That's just for logistic reasons. So somebody has to be here to sell the house, and if they live out of state, it may take them some time to get here. But if you want your son to be your executor and he lives in California, you are perfectly entitled to do that. But yeah, for me, it's just logistics. It's, there are some issues if you're trying to name somebody out of the country. Where I live, it's quite common that we, some of our, well, not my clients these days, but when I was in private practice, we would have clients who owned property in Canada and in the US. And so they may want a Canadian executor. Well, in New York, you have to have then a New York executor as well. But if the executor were out of state, that was no problem. Out of the country, yes.
All right. Let's see, let's go to the next one. I have an estranged brother and do not know if he is alive. I had an attorney tell me they would have to find him when I die. How can I do that ahead of time?
It is a lot of research, and then basically that's it. You know, the internet, it has been a godsend for a lot of things like that. You basically start with the last place, you check Facebook, you check the internet. There's this website, it sounds so morose, but it's an excellent website. It's called Find a Grave. So if you think somebody has passed, you can look up Find a Grave. And usually if they find it, they also usually have family information in there as well. So like if your brother died and you didn't know if he had kids or not, they may be named in that website. So yeah, it is an excellent website. I know it's probably the worst name ever. But let me just make sure I've got it. Yeah, findagrave.com. It's really good. I find so many things there. Also, obviously, online obituaries. And what you want to do is make notes of your research, because at some point, what will happen is, like with the gentleman in New Mexico, if I can't find somebody, I have to prove to the court that I looked for them. So I have to do research. And then I ask the court's permission to point or to print in a local newspaper at their last known address a notice in the paper. Like, you know, those legal notices that nobody ever reads in the back of the newspaper, that's where it's going to be. And so you print a notice in there for 4 weeks with the hope that somebody finds it. But that's the way you end up addressing those kind of relatives have disappeared. You're going to have to prove you've done all this research. And if you do it, and then the lawyer, you know, after you're gone, your attorney can, you know, kind of update all of that. It's really helpful.
Okay. I'm gonna get back to everybody who registered for this, event on this next question, which is there a list of recommended elder law attorneys for Sullivan or Ulster County? If that's something you have handy, you can send it to me and I can share it. I know we can't specifically recommend lawyers, but we can see who's in the yellow pages.
Yeah, I personally don't have that. What I am going to do, because I think I saw something here, I am putting in the chat. Oh, well, hopefully that'll work. The link to the Department of Health's healthcare proxy. I hope that works. You click on it, it should bring you up. Yep, it does.
Okay, and I will share that with everybody who's here. We're almost done with the questions in the chat, and then I'm going to close that. Is that family tree research required only for beneficiaries? What are all the reasons to do a family tree?
You need a family tree because whether or not you leave somebody in your family, whether you leave them something in your will or not, they have a right to be notified of your will, so that if they want to object and contest to it, they have that right. Again, you want to go down to the next living person. So for like me, my family tree, I'm not married or have children, but I do have a brother and sister, and I have a nephew. So my family tree would show my parents as deceased, my branches to my brother and sister, and then if anything happened to my brother, the favored child, because he had the grandchild, then it would go down to my nephew, because my nephew is the next living line, right? And he would, if I had a will that didn't leave him anything under New York law, he has a right to protest and object. So that's how we find out who has those rights. So you don't have to, you're just looking for the next living line, the next living branch. So if you have brothers and sisters and nieces and nephews, you don't need to go out to your second cousin or your great aunt Martha. You're going to that next living branch.
Okay.
And under New York law, they may have a right to object. And so you have to notify them and your attorney's going to have to search for them.
All right. Just a couple more and then
Yeah.
we're gonna go to folks in the room.
Yeah.
I'm leaving my estate to my family members in Poland, which I'm sure complicates things. Does the attorney just get in touch with them? They can't come here to collect anything, but I guess it would just be a financial transfer.
Okay, that's a complicated question, so I'm going to say this. When you leave assets to somebody who is outside of the United States, and I've done this before, so I know it's a pain. You have to serve process on them, like, you know, you have to send them the will, you got to send them documents. To do that, you have to go through the Hague Convention. It's an international thing. And it's expensive. It is expensive because you may have to serve them. What you may want to do instead is go to an attorney and talk about setting up a trust instead. A trust doesn't have to go through the probate process. A lot of times I'll get questions about, should I do a trust? Should I do a will? Trusts serve a purpose. Most of the time I think wills are fine, but there are some instances where trusts might be better because trust can avoid probate. This is probably one of those issues. You don't want to have to go through the court. You don't want to have to go through the Hague Convention. You don't want to have to go through US embassies. You may want to set up what's called a, well, again, depending on your circumstances, and talk to an attorney about this, a trust. So the trust says, I'm putting everything in the trust and can get complicated, but when I die, everything's going to Poland. You don't have to go to court if you've got everything correctly done in a trust.
All right, thank you. That was a little complicated.
It's a lot more complicated than that, but I just kind of like, only a few minutes, talk about a trust.
All right, I'm gonna go to the room here. You had a question
I
that you
did.
wanted to ask. Can you hear?
Can you hear me?
Yes.
Okay, what you just said, I believe answered my question. I wanted to leave my home to my child. She's not legally because of a long story, but is there a way to avoid, I owe money on the house, but would a living trust be a way that I can bequeath it to him without him having to go through probate and not having access to it immediately? How could he have access to it immediately if I die?
So there are probably a couple of avenues. A trust is one of them.
Is it a living trust?
Yeah, a living trust, well, a living trust is simply meaning you made it while you were living.
Oh, I see. Thank you.
Or the fancy word is inter vivos.
Ooh,
Yeah,
Latin.
I spent over $100,000 to learn that.
But
So
we
it-
have the benefit of you. Thank you.
So an inter vivos trust is what you've made while you were living. And what would happen is you would create this trust with an attorney, please, and then title the house into the trust. So you
Thank
want to
you.
be careful with that if you have a mortgage, because you want to check and see, it depends on what kind of trust you have and what your terms of your mortgage are. You just don't want to accidentally kick off what I call is the balloon payment in the mortgage. Usually there's some little clause in there that says, if I transfer my house without the bank's permission, they get to call the loan. I believe leaving it to a trust is an exemption to that. But that's why you want to go to an attorney. You want to make sure all of those are crossed. There's also a life estate, but I probably think a trust would probably be the better way.
Great.
Because also
Thank
that way you can control it if you should change your mind.
you very much.
And if you put one of your children's names or several, let's say you put all your children's names on your deed, do you still need a living trust?
That's a different way to transfer the house. So usually when people do that, they're doing what's called a life estate, meaning that they're giving the property away to their children. They retain a life estate, the right to remain on the property and live there for the rest of their lives. But when they die, the children already own the house. So that's a way you could do that as well. but they're
Go to court.
without having to go through probate. Keeping in
Okay.
mind that while that sounds good on the surface, there are other implications of doing that. There are Medicaid implications. There are pros and cons to doing all of that. So you just have to be aware of all of that sort of thing before you make that choice.
All right, does that mean, is that the 5-year rule
Yes.
for Medicaid? So if someone transfers, puts their child's name on the deed, and that person dies or has to go in the nursing home, let's say, and has to have Medicaid, there has to be a 5-year look back to the
Yes.
assets. Okay, and that's
Yeah.
still, okay, thank you.
Yep. And that can kind of get mean.
Yeah.
Yeah.
All right.
Yeah. And the same
another-
thing with the trust, though. It's the same result with the trust as well. Putting something into a trust, unless you have a Medicaid, well, no, even if you have a Medicaid trust, there's still that 5-year look back period.
Okay. Good reason to do things ahead of time, right?
Absolutely.
So besides a will, what are the other 2 things that we need? And one was a healthcare proxy and
And a durable power of attorney.
durable health
Excuse me.
attorney.
Yeah. And
Okay.
durable simply means it's good whether you're healthy or not.
Durable what?
Power of attorney.
Durable power of attorney.
And if you die without a will and you are single, how does New York law determine next of kin and line of
New York-
beneficiaries?
Yeah. So New York does tell us who your next of kin is if you die without a will. So first person's going to be a spouse. If not a spouse, if you don't have a spouse, or if you have children, depending on what the value of your estate is. If you have children, if you don't have children, then we're kind of going down that tree. If your children predecease you and you don't have a spouse, maybe you have grandchildren. So we're going down that tree. Let's say you die, you're single, so maybe you have siblings. So you go up the tree, you go to your parents. If they're living, your estate goes to them. If your parents are deceased, then you're going to branch out and go to your siblings, right? If your siblings are living, it goes to them. If they're not living, but they have kids, then it goes to your nieces and nephews. Let's say you don't have any of that. When we go up to your aunts and uncles, are they living? Then it goes to them, or to your grandparents. I'm sorry, I skipped a branch. So New York does lay out who is a potential beneficiary for you.
Okay.
But again, you can also avoid that if you have a will and say, I want, we still have to find everybody, but if you want to leave your estate to your best friend, you need a will.
Okay, great. Thank you. All right, now I'd like to open it up. Anybody else in the room
Yes, I
have
have a
questions?
question with the deed. How do you go about, if I have 3 children and I want to put their names on the deed, could you do that, all 3 of them?
You can put anybody you want on your deed. You can put all kids, grandchildren, if as long as they're over 18, please. Yeah, you certainly can do that. You just, like I said, you want to talk to a professional about that, because we want to make sure if you have a lien, if you have a mortgage, we want to make sure those things are taken care of. We want to talk about, here are the pros and cons of a life estate. Here are the potential Medicaid issues. Excuse me. So you certainly can do that. You just need to be aware of, like I said, the pros and cons.
Now, who pays the taxes then? Do I still pay the taxes and all? I just
If
want
you-
their name on the deed.
If you have retained a life estate, meaning you retain the right to live there, you pay the taxes. If you're retaining a life estate, nothing really changes for that person. You still pay the taxes, capital improvements, maintenance, but you also get to keep your STAR exemption, and you get to keep your veterans exemptions if you get those. That's why having a life estate is
I have
important.
all them. I have the enhanced star and
You would keep
I pay the taxes, but I just want because my husband's deceased and my
Mhm.
name is on the deed, but I want to put their name on the deed too. So where do I go to do that?
You can, if you qualify for our help, we can help you do that. If not, then you hire an attorney to do a new deed for you with tax forms. It shouldn't be terribly, I don't want to lie and say terribly expensive, but it's a relatively easy process.
So how do I get in touch with you?
You
I'll
can
give
go
you
to,
the
Oh,
information.
okay.
Yeah.
Thank you.
I'll give everybody the information before you leave. Okay, anyone else?
How do you qualify for her help? What's the financial qualification?
What are the financial qualifications to get help from your firm?
so we determine what low income, we go by low income. However, our guidelines are 250% above the poverty line, which is pretty generous for a not-for-profit. So just as an example, and I tape this in my doors here, so I can tell you. Yep. Ta-da. For example, if you are an individual person and your income is $37,650 or less, you qualify for our services. So we don't count assets. We're not going to count your house. We're not going to count your car. We're looking at your yearly income. Or if do we do it monthly? Yeah. So like if per month, if you're an individual and you make less than $3,137.50, you would qualify for our services. The more people you have in your household, the higher that income level gets. So like if you're two people, and you make combined, have an income less of $51,100, you qualify for our services. So it's a pretty generous qualification.
Is that something you can share with me and I can let people know when they call?
I think I can copy this.
Okay. All right.
And you can
anyone
always,
else?
when you do the intake, they'll let you, we'll figure it out when you do the intake.
Great.
Your number?
Yeah, I'll provide the phone number. I put it in the chat, but I'll provide it for everybody before you go, as well as their website.
One more question over here. I have a question.
Okay.
Let's go here first.
That'd be, right?
Yeah.
With the trust, when, say, you want to put the house into the trust, you said all that matters if there is a mortgage left on it or not. And you can name, I guess, your children on that trust. Now, in that same trust, can't you give your children part of your money as well? Like, let's say the trust is kind of like as a business, if the trust becomes a business and the business owns the house, which would kind of protect the house. My one question to leave from that, let's say you have two children and one of them owns a business and they're an LLC, and let's say they get sued. Am I worried about them, my house being taken if I just put them on the deed? But if I put them into the trust, I'm kind of protecting the house and them, right?
So, all right, so a little bit complex here, but
That's why the big
when you have the point of having an LLC is you protect your personal assets, because you're looking at you're looking at the interest of the LLC. You're not, it's not my personal assets. I own interest in the LLC. So the only thing people could come after is my interest in the LLC. They can't come after my house. All right.
I thought you had an S corp to protect that type of stuff. I thought
An LLC will do the same thing. It protects my personal property, or it protects my assets. Putting things in a trust offers certain protections. It does. It really depends. So again, that's why you're going to want to hire a professional to create that trust for you. You want to make sure that the terms of that trust offer protection. And you also have to look at the terms of the LLC, and yeah, it's a complex issue.
Just make that trust as well, like it is a business, and I could distribute out, monies to my kids before I die out of my money, so they'll be pre-taxed, so they wouldn't have to deal with the state tax and all that. Can I do that out of the trust as well?
You can set up the terms of the trust any way you want, so that you can say my beneficiaries are my children, and once a year I'm going to give them X amount of money from the trust. You absolutely can do that. I would not worry. Well, I don't know what your assets are, so I don't want to say not worry about estate taxes, but New York's estate taxes, if your estate's under, I think it's $6 million, we're not worried about taxes. Federally, if your estate's worth less than $13 million, we're not worried about estate taxes because everybody has a credit that pays for those taxes up until that amount. So, like I said, if you're looking at something like that, if your estate would face estate taxes, hire a lawyer. You can hire a lawyer and get that dealt with because you're going to look at complex issues.
All right. Is there a way to determine what happens to assets after your beneficiary dies? For example, not to go to their wealthy sibling.
Yeah, so you want to name alternates. So you can name alternate beneficiaries. And you can also name alternate direct beneficiaries on accounts. So let's say on your bank account, you named your son, and if anything happened to your son, then it goes to your daughter versus your other son. In your will, you can say, I leave everything to my son A. If my son A dies, then these assets are going to go either to my other children, to one child, it could go to A's children, or it could go to charity or your best friend. You can always name alternates.
Okay, if one of the siblings is going through a divorce and there's like, they are a beneficiary, right, of when a parent dies, does that child's spouse, are they entitled to the asset?
Typically not. What can happen is, let's say the wife inherits $100,000. That's her money. But if she uses that money to pay off the mortgage on her house that she jointly owns with her husband, then she doesn't get that $100,000 back when they divorce, because now it's a joint asset and it's subject to the rules of divorce. So if your marriage is in trouble, keep your property separate.
Okay. Anybody else in the room?
Yes, I had a question.
Go ahead.
Part of the homework was making a family list. So you start with your spouse, children, grandchildren, and then I have lots of brothers and sisters. So in that list would be brothers, sisters, nieces, nephews, and so on, right? But
Right.
you don't have to disinherit nieces, nephew. You don't have to specifically say.
No.
No, so you're saying who you want to inherit, but you're giving the list so you have it, but not that you have to disinherit anyone.
Yeah, so for you, when I say make a family tree, I would say for you, list your husband, list your children, list your grandchildren, right? You wouldn't even have to list your brothers and sisters because your tree has enough branches that I'm probably assured that I don't have to go to your brothers and sisters.
Okay,
So yeah, you're going down the tree, right?
okay,
Husband, children, grandchildren. That's perfectly fine. If you had none of them, then I would say, let's look at your brothers and sisters and your nieces and nephews.
okay.
And
Thank
your
you.
parents. Don't forget your parents.
Yeah, thank you.
All right, I'm gonna take just another couple of questions from the room and then we're gonna wrap it up because I think you promised an hour, but we've been here for an hour and a half.
That's fine. I talk. It's half my fault too, because I'll talk.
Anybody else?
Their firm offers help for people, you know, who are, in need. If you are above that price range that you were reading off of your, paper, does your firm still handle the business? There just might be a charge, or they don't even handle that?
No, we don't. We don't make any. We don't charge at all. We are grant funded, so we do not accept payments. Thank yous, thank you cards, occasionally a pie. Cookies are always welcome. But no cash. A donation.
So,
Donations are nice, but
so would you have, some recommendations of other attorneys, you know, that you would recommend for people who fall into that category?
unfortunately, I'm not familiar. I live up in Clinton County, so I'm not familiar with the attorneys in your area. So I couldn't tell you. I couldn't tell you who's there. I would, if you're looking for attorney, I would specifically look for them to mention that they do estate planning.
Okay, so I'm looking for an attorney that would mention estate planning.
Yeah, we also have, some community resource guides on the table out there, and I think there's some attorneys listed. That are in the county.
Thank you.
Anybody else? Yes.
I just want to say, this was fantastic.
Yeah.
Yeah. This was so informative. Thank you.
Thank you. We hope we hope it's useful, and this is, what we like to do. And we do lots of other stuff too.
Can I ask a question?
Somebody like you in
Certainly.
Sullivan County?
Hello?
No.
Somebody had a question?
We have any.
Yeah, we've got some talking going on in the room here. Let me see, who's trying to ask the question?
Hello, my name is Bill.
Yes, Bill, go ahead.
What happens over time, say if I designated my spouse as my agent for this, that, and the other thing, and then her health fails in the meantime, and the written document is in place, but she is really incapable now? How does that evolve?
So that's why you're going to have alternates named. So that if the first person is incapable or has passed away, you have already named a backup. And again, you can always update these documents. So if you have a power of attorney and your wife's health is failing, maybe you want to redo that power of attorney and name somebody else as your agent. And I cannot stress enough how helpful it can be having an alternate named. So absolutely, you can change and update that document and name alternates. Absolutely.
Right on, that was my question. That was a good answer, thank you.
You're welcome.
Can we have consultants as part of the healthcare proxy? An agent, an alternate, and consultants?
Well, the healthcare proxy is one person at a time. And only one person ultimately makes the decision. In your family, you can certainly say, I'm going to name Joe as my agent, but Joe, I really want you to talk to the others. But ultimately, Joe's the one who has to make the decision. And again, if you have specific wishes about something, you can put that in your healthcare proxy.
Okay, thank you.
All right, well, I think we are going to wrap it up. I have somebody on here who recommended a couple of attorneys in Sullivan County, Annabelle Bazanti and Marty Hirsch. At HERSH. Those are two estate lawyers in Sullivan County. And as I mentioned, the community resource guide put out by Sullivan 180. We have plenty of those. If anybody, you can also get it online, I believe. And I will follow up with everybody that registered for this today by email and give you these resources so that I don't get 52 phone calls.
Good job.
All right, this will be recorded and it has been recorded, and Heather, I'll follow up with you to see if we can share this and in what capacity. And again, thank you so much. We really appreciate this resource. All right, thank you, everybody who joined us.
It's been fun. Thank you, everybody.
Thank you.
Thank you.
Thank you. Thank you.